3.8F specifically prohibits a prosecutor from making extrajudicial comments that have a substantial likelihood of heightening. The kind of comments that Mr. Nifong was making about this case were not only likely, according to his testimony, to some degree, they were designed to increase condemnation, to put pressure on the players. And these are just some examples of things that he said during this proceeding. Absolutely unconscionable. Gang rape, one of the worst things. Racial epithets, particularly reprehensible. Racial slurs, totally abhorrent. Bunch of hooligans. They are clearly going to cause public condemnation of anybody who is eventually charged. The State Bar has provided various documents and the testimony of both defense witnesses and prosecutors establishing clearly and convincingly that the statements not just had a likelihood, but in fact did potentially prejudice the proceedings, but also heighten public condemnation. The most compelling evidence of the condemnation of the accused is this picture from Mr. Seligman at his initial appearance, as he testified about yesterday. You could not have a worse example or better illustration of heightening public condemnation of the accused than death threats being made against a defendant while in open court in North Carolina. To make this violation even more egregious, these threats were directed at a 20-year-old fine young man who we now know from the Attorney General was innocent of the charges brought by Mr. Nifong. The same defendant that Mr. Nifong's lead investigator had attempted to convince him not to indict before this. Further indicative of Mr. Nifong's misconducts and intention in this case, Mr. Nifong, during this same hearing, openly laughs in that same hearing in which Mr. Seligman received death threats at substantial evidence his attorney amassed in just 1 week in trying to prove that he was innocent. Mr. Nifong also admitted in his comments to the press were designed to do that because he wanted to put pressure on the players to come forward. And that was an attempt to circumvent the advice of their attorneys, as he acknowledged, who were advising their clients to exercise their constitutional right. As Mr. Tom Anglem said at the end of the evening yesterday, these extrajudicial statements effectively nullified the defendant's essential constitutional rights and guarantees to silence and the presumption of innocence.